Thank you. Welcome back to Senate Economic Development. We are turning now to our housing bill, and our hope is to get the housing bill out this morning. We have three things we still need to land. For a number of reasons, we have our immigration status, which we'll talk about with Pam. We have our appeals conversation, and we have our credit score. Those are the three pieces. I think we're signed off on pretty much everything else. Is that correct, Pam? Roughly? Yeah. So those are the three pieces we need to come into either can find some consensus on, or we need to make a decision about. So we have Ellen here, and I know we have Kathy. I see Kathy here, who I think wants to weigh in if she has a moment. Is that correct, Kathy? And I know there are other people who are going to be coming in at some point who may want to weigh in. But I would love to. We've had a pretty full conversation about the options in front of us. Ellen, would you like to just simply reiterate the options that we have at the moment, or you want me to?
Well, Ellen Tchaikovsky, Office of Legislative Counsel. So I was here yesterday. It's sections 15 through 18 of your draft.
It's in our latest draft. It is 4.1.
Yep, from yesterday. So this would be changing the existing municipal permit appeal standing from interested person to person aggrieved. But you have talked about a couple of variations on that. And so interested person has 5 definitions. You've been going back and forth about whether to eliminate 3 and 4, or just 3 or just 4. Or including something different. And person aggrieved is the standard that is currently used for Act 250 permits and A&R permits, and outside of the permitting realm, other types of appeals. You have included clarifying language because person aggrieved is about a particularized, an injury to a particularized interest. You have included language that says it does not this standard would not be used for any permits that have already been applied for. And
right.
Yes. And so you discussed yesterday a couple other different options. I think Senator Chittenden would like to speak to it, but one of his proposals was to delay the effective date by a year. I think those are the options you at least discussed, and you've discussed a few other things as well, but I think that's the high level version of what is in here.
Right. Thomas.
So what I did take the liberty of, and I did CC you, Madam Chair, but I have not.
Sorry, I don't have my computer. One of the reasons I had to be out is I left it.
Based on this conversation yesterday, what Ellen, and it's in your inbox, was so gracious to pull together is 4 potential changes that I thought might thread the needle on this. So what I have on the screen here is.
Can you, yep. Mr. Tech, can you make it bigger?
Oh, I need to send it to Heidi, don't I? Okay.
Great, perfect.
So this retains a lot of what the House has, but the concern or the notion that was raised is by broadening it to person aggrieved, really opens up the universe of potential people who could apply. One notion that percolated to me is using the same proximate qualifier that we have in item 3 for interested persons, adding that to the person aggrieved for this first statement. So basically it would limit it to persons aggrieved that have the same qualifying proximate location qualifier as the interested person, saying a person aggrieved owning or occupying property in the immediate neighborhood of a property that is subject to the decision of act. So that, in my mind, would contain the person aggrieved to the same proximate boundaries that we have in the interested persons definition. I thought that might be worth considering. I'm not a lawyer, so I don't know what the implications of that are. The other notion that came up in conversation with Judge Zone, this is item 3 for interested person, who my take from his conversation is that current case law has interpreted this to require injury or to require some sort of standing being through an aggrieved process, but our statute does not show that. And as I do a plain reading of this language, The one word that I just think is too vague is that impact, because to be an interested person, as I read this, you just need to demonstrate physical or environmental impact. That could be positive or negative, or who knows, not getting into the character, the site. It's just impact is too broad for me. And if we do want to limit this to people that can prove injury, I thought just changing that simple word to grievance, but I think injury is better, thanks to advice from many individuals. And then there's one more change that did not come up yesterday. Also included in this is the notion of extending the date. But the one other thought or suggestion would be to expand the LURB appeals group. Since this does propose, and I don't know where the committee is on having this take effect next July, but since that LURB appeals group, as I've talked to individuals, seems optimistic that they're going to come forward with some thoughtful and consensus around appeals. This would just make sure that and this is just my first stab at language, it seems to strike at what came up, just make sure that they need to consider whether to make changes to standing requirements for municipal permitted appeals, basically this topic area, to reduce frivolous appeals and uncertainty. So adding to their charge. So those are some things I thought I'd put on the table, Madam Chair, in an effort to move this along. I feel like this addresses some of those concerns, knowing that SNRE is going to get this and they might make changes, or then the House Committee of Conference could also fix this as well. I don't know if you have any thoughts, Madam Chair, but that's what is in your inbox.
I have lots of thoughts, and I apologize. As many of you know, I had to leave the state for something important and got back very late last night and haven't had a chance to look at anything. So thank you for doing this, Thomas. And so there are 4 changes.
It collapses one of the categories.
No, it adds, I think it adds.
So it does get rid of any 20 persons.
That already was gotten rid of.
Right.
Right, in the House.
Oh, yeah, but that's a big.
So,
And,
Ellen, why don't you review what you've drafted for?
oh, sure. So I mean, I think Senator Chin did a great job of doing the overview. And so this would be still using the person aggrieved, but modifying it so that it's a person aggrieved owning or occupying property in the immediate neighborhood of the property that is the subject of the act or decision. And so that is narrower. And so I guess one of the questions that is sort of open here, because then the next change is about changing in the existing 3 physical.
So this change is in, remind me
Sorry.
where.
The first change is in section 16. So it's on page 2 of this amendment. And so
Right, under V1.
Yep.
Right.
Yep.
Can't show both, V1.
Great, yeah. So it would read, or a person aggrieved owning.
And so this would, if you're, it's page 31 in draft 4.1, it would just be inserting this highlighted language.
Page 31.
Yeah,
Yep.
V1.
And so,
Begins on line 16.
yeah.
The attempt is to narrow person aggrieved to those that have the same proximate qualifiers as the current interested persons.
Ellen?
Yes,
This is still the first.
yep. And so,
Yeah,
that's,
And this is the newest one. This did not percolate yesterday.
right. No, I appreciate you taking the time to do this. This is
It's good.
This is,
I like that.
and then we keep the language about the date that it's not retroactive before July 1. Then the next one is in 3 on page 34, right?
yes.
This was inspired by Senator Brock, really commenting on how we might want to revise the 3 and 4 range of zoning.
So 3 would be, could we do impact
I think
or injury? Just because there may be an impact, but not necessarily injurious.
Well, so I wanted to make sure I understood your intent, because you are leaving 3 here. So you do want to are you proposing to have both 3 as an option for appeal and your modification in the first part?
Yeah.
I think you are.
Yeah.
Yeah, okay.
If somebody is truly aggrieved or injured, I feel like they should be able to appeal.
Right. I agree.
Okay, so
Would it
these
be
are
injury-
pretty close.
Injury to the persons as opposed to on the person's interest.
The environmental,
Line 6.
All refers to the person's interest.
Sure, you could, yeah.
but
Injury to versus impact on, two makes more sense.
Can we,
If impact is out, then we should be injury to.
I wouldn't necessarily get rid of impact. I guess I would say impact or injury.
I would think it's injury that we're looking at.
Mhm.
Impact doesn't mean anything. It
Well,
could be
you may have
impact
an impact-
favorable, it could be impact.
You may have an environmental impact that isn't injurious. I mean,
An example of what you mean by that?
I don't know, but
we took out character of the neighborhood, we took out more
Right.
of the aesthetic concerns, so what would be an environmental
I
impact
don't know,
that's not an injury?
versus, I mean, they're,
I also had grievance originally, but I think injury is better.
Can we say particularized
Particularized impact?
physical or environmental injury?
How does that
And I think it
change?
has to be an injury, not an impact.
Particularized is important from my understanding, because otherwise you can just say it's gonna emit too much
Right.
Mm-hmm,
CO2 or traffic.
right.
It's not particularized. Particularized is this is going to affect the turnoff on my road.
Yep, got it.
I'm uniquely impacted vis-a-vis
right.
my other neighbors or anyone else in the community.
So where would you add that, who could demonstrate a particularized? Ellen, where are you?
Yeah, particularized physical or environmental injury.
Okay.
I don't know what impact means. Injury, I know what it means.
Yes.
Maybe I might ask, I see John Groveman's joined us, Kathy's joined us. Would you see either of you who are experts in this area, a difference between impact and injury? Because it strikes me that there could be an environmental impact without it being
Well,
injurious.
exactly, but that's the point. So what I would say is if you can demonstrate a physical impact because your view is blocked, that's not an injury. And we're trying to get
Right.
rid of those kinds of concerns.
I appreciate, but there may be something more than that, and I'm just concerned about that. John, any thoughts?
For the record, John Groveman, Vermont Natural Resources Council. I think injury is actually the right word because that's the standing requirement, but I do have I have a concern about saying to be a person aggrieved, you have to be in the immediate neighborhood. I've done some research on it, and I don't know if Alan's done any research on it, but I'll go back to my office today after the morning, but I think, what I've
You
read.
mean in the first, sorry, you're talking about the proposal in B1?
Yeah, if I understand it correctly, is to basically, to get rid of the 20 people who could petition, which I support that, and then say a person agreed, but that person has to live in the immediate neighborhood. My concern is that is a below the floor constitutional standing. Like, the reason we got person agreed for Act 250 standing and A&R standing is because that's what the U.S. Constitution basically says. And Ron Gems alluded to it
Right, in his letter.
that the statute, the Administrative Procedure Act incorporates that already, because that's sort of the floor, like if you have a legitimate injury and you can prove that, I think there would be some argument that even if you don't include that, like someone would say, hey, we're a person agreed, we don't have to live in the immediate neighborhood, however that's defined, we could prove an injury under the US Constitution, we're entitled to appeal, which is why, I always thought it makes sense just to codify that. And that's basically, I think, what the House was trying to do. And that was Chair Mahali's point of view, but I have to go, anyway, that's my concern. I don't know if Ellen has thoughts about that.
So I think the risk then is, if you include this, is that a court could find that this wasn't a valid way to define standing, and then they would, in their case law, expand it.
So you're
you-
concerned that because
I'm just-
US,
I'm just pointing it out. You could include it, but that could be subject to challenge at the court, and then they would decide if this was an unconstitutional limitation. I hadn't given a ton of thought to that, but it was based on your suggestion.
But what I was interested in is can you give me an example of what you might mean that someone suffers an injury and they are nowhere near the locus that we're talking about?
And can we be clear that we're talking about an injury in the granting of a municipal permit?
Right, so.
That's the critical
Yeah, I
part.
mean, I agree, and I just got to say it natural, but I think you talked about this as well. What Ellen has tried to do, and I agree with, is say the injury has to be tied to Title 24 issues. That's the language that Ellen drafted, and I think that makes sense. So that's the injury. The immediate neighborhood is not a defined thing. It's not like a math thing. It would be a case-by-case analysis. You could live, there could be a zoning provision that addresses traffic, and let's say it's a quarry, and let's say the quarry trucks are going down the road and then make a turn onto another road, and you're not in the immediate neighborhood because
Or even in the same town.
Yeah, but let's keep it for simplicity, let's say you're in the same town, but you could be on not the road the quarry's on, but on the next road, but the trucks are going that way, so your impacts, your injury is potentially the same.
But wouldn't that be a transportation impact assessment, not the municipal permit?
No, the municipal zoning has criteria about traffic and that could be a character of the area issue, but let's just stay with traffic. It could be traffic, that could affect you, and if you have dozens of trucks rumbling down the road right in front of your house, shaking your foundation, that is an issue. That is a potential injury that I think you would have a legal right to address. And I don't know that you'd be in the immediate neighborhood. And so, I can see if it was my client, I would say, and I came in and then I said, well, we want to have party status because we want to address that issue. And the applicant says, well, you're not in the immediate neighborhood. You're not on the exact road. You're on the next road. And I'll say, well, under Constitution, we have standing. We can show we're a person read that we have an injury. And under the U.S. Constitution, we have a right to have those concerns redressed. And I think that's a good argument, whether you put it in the statute or not. So, and if you did limit it this way, I think it could lead to litigation, and it would lead to situations where if people were statutorily excluded but had a legitimate injury, they would try to protect their interests, right? They would try to protect their property.
Tom.
Two things to that, where I'm trying to thread the needle on this is if somebody's agreed that they have constitutional standing and they should absolutely have their day in court, my expectation is that they would hopefully have other avenues more relevant than a municipal permit appeal. I just think of these municipalities, if we broaden it to that universe that Judge Zoney said we would be doing with the original language, all of a sudden municipalities, Richmond, Bolton, Putney, will have to start upskilling on all sorts of possible grievances from any interest that could be well outside the scope of what they do, which on a day-to-day level, by allowing national interest groups or other people outside of the state or far away talking about aviation issues or CO2 or some other impact. So just broadening that world, keeping it outside of the proximate location of the municipal permit, I feel like this is narrowing it for the municipalities to have to deal with appeals relative to the permit they issued, so as to not expand it to that realm. But to the realm that you mentioned, I would expect they would have avenues in civil court.
Well, no, I mean, their due process is about whatever the permits. The zoning permit could be the only permit. You have to be on, let's say you have zoning, you have to have a project on 10 acres or more to trigger Act 250. So the zoning permit, if you had a quarry on 8 acres, the zoning permit might be all that there is, So, and zoning permits are, they're ways to regulate land use just in the same way as Act 250. And so I think that there is a right to be heard if you're potentially injured, which is, in my view, all that we're trying to do, with the House is to try to. There is a lot of confusion about this. There's no doubt about it. And just to create clarity, and there would be less litigation in the long run if we basically recognize the constitutional floor and we get rid of people can sign a piece of paper and petition and not have to worry about whether or not on the Capitol Plaza decision what the Vermont Supreme Court would do if that was ever challenged, because it isn't I know statewide precedent yet, and just be clear and make all the standards consistent among the three major land use permits we have, which is zoning, Act 250, and A&R. And so that's, anyway, that's my concern with trying to narrow it in this way.
Robin. I would just say, what I'm getting more comfortable with in general is that this should all be short-lived, because we need to start figuring out with the LURB dispositive permitting. That if you go through a municipal appeal and you claim a particular injury, that unless something materially changes about your appeal or your standing, that you not be able to appeal again. So I'm making peace with any of this, because I hope that in the very near term, as soon as next year, we are working on collapsing duplicative processes and giving people clarity about where and when a decision is made on a particular topic, and that unless you are going to the Supreme Court only once, that topic is closed.
I like that. And that's also why I like the 2026 thing. I have optimism that the LURB's appeals thing is going to come back in January and tell us to just redo all of this. Well, and have lots to do.
And that's where we began.
Yeah.
The only question about 2026 is if you adopt this earlier, are there one or two appeals that won't be filed, that would not be filed if you had more sensible?
I would echo Judge Zone, and what I also heard Chris Roy is that if you change this, it's going to create a lag in the system as the new language is challenged. And that's why I like the 26, because then if anything we do in January, it'll all be the same lag. Or
So
less.
anything we do next session, right? Would.
That's good.
That's good.
I agree.
So and Kathy, you're here, and I know you'd like to weigh in. So, no, keep going there. This is sort of a conversation. Let's just do a conversation.
Thank you so much. For the record, Kathy Beyer from Evernorth. Been here before. Nice to see everyone. I listened in to Judge Zone's testimony yesterday, and just sat in Senate Natural Resources with John, and listened to John and Judge Zone. And I have to say, as an affordable housing developer, for me, the single most important thing to keep in statute is the immediate neighborhood requirement. And when you think about it, flawed or unflawed, it is narrowing who can appeal our projects. You have to be in the immediate neighborhood. I can give you an example where in the town of Guilford, we had a property where we had a parking garage that has to be, you have to have lights in the parking garage. They're not creepy at night. And someone in the town appealed that permit, and the judge pretty quickly ruled, you're not close enough. I mean, did we increase light pollution in that town or in that vicinity? Yes, but the person who appealed could not see the garage from where they were, and so that was dropped. So I have seen this as it's just the fact that if you keep the immediate neighborhood language in there, we're reducing the potential of violence.
And the latest consideration before Tom presented this proposal was to keep 3. So there was, I think,
Okay,
there was a
changes
lot of effort.
many times like that, yeah.
Right.
And then I would just say, I actually don't think it should be compared to Act 250 and A&R appeals, because your municipal permit is based on the local zoning, which is different town by town. So the framework is the zoning ordinance. That's your rule book. You should be able to build this housing if you comply with that ordinance. And so to have an aggrieved person who might not even live in that community talk about something that might have more regional impact, which might be appropriate at Act 250, I don't think is appropriate for the local permit. I'm not a lawyer.
That was more simply said than I've been able to do for weeks. So thank you, Kathy.
Yeah.
So, committee, we have a proposal on the table to incorporate this language, Tom's suggestion. the concern is that it may have a challenge, from an aggrieved person who, on a municipal permit, and they may be able to find standing. But at the moment, we're continuing, to support number 3, getting rid of number 4, expanding number 3
Can I
a
look
bit,
at 3?
and
This is 3.
think those are the,
No, we're only not,
and moving to injury, right?
so we're not getting rid of them, right? What we're doing is we're waiving their applicability for,
No.
the appeals, but for bylaws. and
For
things,
bylaws,
they're still
we're-
applicable.
Right. So Ellen, as we understand it now, you would be, these changes include section, what does it do to section 15? So
Are
you just
we gonna
walk-
add particularized in 3?
I think she took note.
Okay, I just wanna make sure we're all in agreement on that.
So,
If
sorry,
we're-
let's just go through it, section 15 through on, because then just be clear on the changes, because we're gonna hopefully be trying to vote this something new. So, Ellen,
So the only change there's no change proposed in section 15.
that's the definition, right?
Oh, let me look at person aggrieved. Okay, it says,
Okay, we're not changing that, but we're doing
That's
this,
just the
the
definition,
notion of adding here.
And then section 16,
right, is where the key changes.
Yep.
Okay,
One other thing, if I may, Madam Chair,
Yeah.
on this is, I don't think this conversation is done today. If we include this language, SNRE is gonna get their
yes,
mitts on this.
if we
and then-
include this will go to SNRE. Okay,
That makes me more comfortable with adding it.
it will continue to be reviewed.
Yeah, I'm just make it one last thing. and
Yes,
I'll
John.
never- I'll never say anything about this again.
Don't say never, because we know it's not true.
I want it to be true. Can it be true?
you and me both.
I just Googled it out of curiosity. What is New Hampshire if you want to appeal a zoning permit? And this person agreed. It's constitutional standing. Because I think.
Well, they also have a housing board of appeals.
I.
They also have a
I'm just-
coherent
I'm just saying that because that's the core. And even New Hampshire,
But
free or die New
The
Hampshire.
problem with all of the conversations that have happened until the bill got to this committee is that it was outside of the context of Vermont and our 3.5 layers of appeals that we have not reckoned with. So adding the same standard that exists in the 2 other appeals processes to this standard does nothing in my mind to narrow the ability to appeal.
I just think if you could not require a permit, I agree with you, Senator, if you have a permit, whether it's a zoning permit or any other type of permit, you have these due process rights, and that's why we won't have these permits,
Right.
certain permits in tier 1, I agree, we could reduce duplication of permits.
It's not just not having permits, because I don't want to sound like that's my only solution to things, but New Hampshire has created a coherent flow chart
Yeah.
of
Which
where your appeal goes. And when we looked at that last biennium, there were only new layers of appeal put on top of the existing framework. There was nothing collapsed, and it was new money that was needed. So it was adding a housing board of appeals to the already 3 layers of appeals that we have. I am very much seeking from the LURB or Gus or whoever wants to bring this forward, a coherent flow chart of appeals that's not what I keep showing on the screen. That's not coherent. So that you are not relitigating the same issues with the same people
Right.
more than once unless they're appealing based on material facts on the ground from the previous court.
Yeah, I hear you, we had a 3-hour appeals meeting on Monday, we have another one next Monday, and then
Yeah, we're
another one the
hopeful.
following Tuesday,
And this,
you're gonna get a suite of these recommendations. but-
we don't want to be hijacked by that conversation, but I would hope that you would be that the LURB would be hearing us in this need, and I think it would be to have that coherent flow chart of appeals so that we get rid of as much duplicity as possible would be the duplicative challenges, of course, I hope being represented in that conversation.
It is.
Yeah, I thought so.
So if we're talking about getting rid of 4, can we look at 4 in total? Because I want Kathy's opinion on this.
But also just 4 is included in bylaw, in the opportunity for bylaw appeals. So it is in town planning and in bylaw appeal. This
Hold on, I want to ask Ellen and Kathy.
I'm gonna zoom out.
Right, Ellen? Can you just clarify where we're keeping?
Yeah, keeping 4 for plan and bylaws.
So any 20 persons can appeal the town plan or the bylaws, which we've gone through in lots of communities too.
Right.
Once it is put in the town plan or bylaw, are we saying it cannot be appealed?
What?
The project that was already inserted into the town plan?
Well, so projects are not in a
Yeah,
town plan or
this is about the
bylaws.
permits for those projects.
Yeah, there's a.
Those-
Okay, because I mean, I thought that came up with Putney was that the town plan included housing in this specific spot. And then the project was still appealed. So what I'm just asking this because we tried to use this section
As a way
to
to limit it.
limit others, saying, you know, I am adjoining, frankly, was the person who appealed twice to the Supreme Court. I am adjoining. I don't like that housing designation was added in the town plan here. I don't want housing next to me, even if the town wants it. So are we, I'm not married to this language, but our intent was to try and make them participate in the planning process and then be done.
That, Thomas, because until we make that planning process, it gives more weight to that planning process and sort of end appeals at once it's gone through that. I mean, there is a proposal in the body that we consider doing something like that, but it hasn't yet come into legislation for us to consider.
I hear your concern, and I might pose it to those that I think might know this better. I don't know the answer to this. So if you have a permitted a project that gets a permit and all that, if somebody appeals the bylaws that somehow affect that, do they ever intersect? Like, could that appeal of the bylaws at all? I guess the judge could say no.
You're, at the time of the appeal, the bylaws that are in effect is what you're appealing on. You can't change
Right.
So fighting the bylaws can't affect that process.
There's a time lag.
Okay.
Because the bylaws are adopted first before someone can apply for a permit under those
So I
bylaws.
think that addresses your concern.
Okay. Let's just review what we're looking at now. Because I think we're ready, I think we're poised to sign off on this proposal.
And so in section 17, in number 3 there, you have the change in number 3 to injury, but you are also adding language. So
Particular use.
yeah, so number 3 would be a person owning or occupying property in the immediate neighborhood of a property that is the subject of any decision or act taken under this chapter, who can demonstrate a particularized physical or environmental injury to the person's interest under the criteria review.
And then the last change is
2 more if you count the date change.
the date change.
Right, so on page 8, you're adding a specific directive for the LURB appeal study to have them look at whether to make changes to the standing requirement for municipal permit appeals to reduce frivolous appeals and uncertainty. And then,
I believe they're already doing this. Is this, John, is this correct? They are already doing this. I mean, it doesn't hurt to say it, but it's,
I heard,
well, so we can.
I think they are. I mean, my only concern is that we're already meeting, and I would ask Gil, what he thinks about this, but,
in my conversation in the hallways after yesterday's meeting, I know they're doing it for Act 250. It wasn't clear that they were also in their scope charged specifically with municipal permit appeals, so that's.
we gave them, actually, it gives them the opportunity to consider everything. But I don't think it hurts for us to add this. That is the hope. It's
Well,
definitely the
then-
hope to align them.
Then would we add A&R?
They're already doing
The-
it.
Not 250.
No, that's not.
No.
I refer back to my chart because maybe our committee beginning of next year should start with the layers because I worry almost everybody is not clear on that. But put my chart up, but it's municipal, A&R, Act 250, federal, which is more likely to be traffic impact. So we had actually made them only very specific to Act 250. This is honestly news to me that we think they're going to tackle the entire question, and I think we should be careful about how much we ask them to do. I don't think we asked LURB to focus on the mapping, and where those maps designate the tiers, there is far less ability to appeal a housing decision. When you get into streamlining the entire appeals process, we deleted that language from last year's bill. That was a request from the governor, and we agreed that that was a lot to ask the LURB to do as it was newly forming. My understanding is there are different configurations of people working on appeals streamlining, but I don't know that the LURB could streamline all of those appeals processes beyond Act 250 because we decided that until we have a totally better proposal in place, it's problematic to have the appeals from, Kathy, I might get this wrong, but it's problematic to have the appeals from the municipal side go to the LURB if they are also determining the maps or something or other, because they're basically supposed to be helping the communities develop their maps. And
Well,
environmental court was still very functional to be able to handle municipal appeals.
Tom and then John.
So what I'd say is, I'm fine with dropping this, and I definitely don't want to derail their effort, because everybody I talk to on every side of this important topic seem to have a lot of hope that they're gonna do some good work. So broadening the scope, if that derails any of that, I say drop this. And I would say, I'm thinking, since I have so much confidence in Ellen, that when we come back in January, if we see what their work has done, it will inform maybe some changes to this municipal aspect, absent or dropping this language.
Yeah, I'm not sure we need this, but because John, do you have something?
I'm sorry.
Go ahead, no, go ahead.
I just want to tell you what's actually happening. Like, so we had a meeting on Monday.
Who's we?
We, the appeals study group, 35 people.
Yes,
Including dozens of lawyers, mostly business lawyers.
right, separate from the LURB.
The LURB is running the.
No, LURB is running
The
this.
LURB Appeals Study Group.
That was your first meeting.
Oh, I didn't know we put it under the LURB.
The LURB is charged with the study, and they have identified 35 people to participate, and I'm one of them. There are, I think, 4 topic areas: consolidated appeals, municipal, A&R Act 250, prioritizing housing, Act 250 municipal. At the first meeting, we looked at statistics for municipal Act 250 A&R permits. We saw actually that there were like 2 Act 250 permits that affected housing and dozens and dozens of municipal permits that affected housing.
That's why we did municipal first.
Then began to talk about, and the third topic is whether we should have a board hearing appeals or the court. And what became evident is that you can't talk about, you have to talk about all the permits, because if you had a board hearing some, and there's also a conversation about consolidating appeals, at least you have to talk about whether you could consolidate appeals at a board as well as a court. We're talking about whether using hearing officers might expedite appeals, including housing, so that courts can't have hearing officers, but courts can. So the reality is that we're talking about all of it, because you can't separate them, because we have 3 major land use permits, and that's A&R, Act 250, and municipal. And if you wanna talk about a rational appeal system, you have to talk about it all at least. And I don't know what the recommendation will be, and then the policy choices will be for all of you, but we are talking about it, and it's impossible not to talk about it.
I'm really curious. I mean, I'm curious because the problem always with the LURB was while they were doing the maps and hearing appeals on the maps, it would be hard to hear individual cases that would be impacted by the maps.
Yeah, I don't think the cases would be impacted by them. I mean, I think, I have never heard that concern, and I don't personally
Oh,
hear that
that's-
concern, but
That was a big part of
the maps will be done, before the legislature ever decides on it, whatever you do with appeals.
Well, the maps can be appealed, though. We limited that in this committee.
Yes, we do.
Yeah, well, this is a whole separate conversation.
Okay.
But that has not- that
I
has
would like to
not-
bring us back to the language that we're about to vote on if we can.
This was a huge
I would
conversation.
propose we pull this number 4,
Yeah.
and that we consider Thomas's language as an amendment to this draft.
Do you like the dates too, Madam Chair? The 2026?
I'm not sure we need it, but, I don't think it, how do people feel about the dates? I mean, we are asking the LURB, we're gonna have more data and a recommendation by, the beginning of our session, which we'll be considering. We'll have a flow chart of the current appeals. Hopefully they will have a flow chart of what may possibly be. So what would?
This is my argument for it, because absent the delay, then this July 1st, all of a sudden this comes into play and we get really
Right.
talented lawyers in
we
Vermont
want
that come
them
in
in
and
sync.
challenge these things, and it creates a backlog. Judge Zoney talked about it.
I agree.
Yeah.
Otherwise, they're not in sync. I'd
Right.
like to have them very much in sync. What are people's feelings about this proposal at the moment? Randy?
I'm agreed.
Was David about to go? I'm
No,
reading.
Andy?
Um,
Keisha? I know where Tom is. I think.
it sounds like all of the other provisions keep the nexus of aggrievement close to the project geographically.
Correct.
In which case, I'm thrilled to get rid of number 4.
Correct.
Thrilled.
You want to do it this July?
Huh?
You want to do it this July and not next July?
Yeah, great. I mean, Charlotte's gonna scream at me about bylaws, but, sure.
Yeah, and the only challenge will be if there's a change in the LURB recommendation, we'll have to incorporate it next year. That's all. It won't be the end of the world.
How about that?
So I really wanna say my intent out loud, as long as all of the other factors keep the nexus very close geographically to the project.
For
What it says
municipal permits.
if SNRE drops the language Mr. Groveman highlighted concern with, then I would push harder for the 2026.
Right.
Mm-hmm.
So that's what I would say. So maybe having a
So-
2026, but
The only plus of 2026 is that we wouldn't be doing another duplicative. I mean, our work would be aligned. But
It still has the no look back.
yes,
Okay.
yeah, no, with the date beginning this July.
I'm actually, there's a reason I'm saying my intent very loudly and intentionally, which is this becomes the subject of many, many conversations on one side and lawsuits on the other once we are done. So if everyone is agreeing that we are keeping the physical nexus in the municipal permitting process as a key component,
I'm in agreement with that.
thank you.
As am I.
Yeah, I'm good. I
Okay.
agree.
Time, I'm just concerned about the time. I mean, I'm happy. I'm just a little, I'm unsettled on the time frame because part of me very much would like to do it in sync with what's going on with LURB. But on the other hand, we want to be able to do this pretty immediately and have some impact before we enact all the LURB things. So I'm happy to keep the date that we have and put this date to 25 and make them both 25 and the retroactive one piece. So with those changes, you're okay? Randy, you're okay? Thomas, you're okay? Where are you?
I'm good.
Okay, great. So we will have, are you?
When you need to look 45.
Okay, we'll get Cam back there and go over the other 2 pieces that we have to land before we approve what may be draft 5.1. Thank you, Ellen. Thank you, John.
Thanks, Ellen.
Thank you, Kathy. And Ellen. You need a plug for your laptop. Okay. So the last two pieces, committee, we have been discussing the lot rent, caps in this, but I don't think we have enough time at the moment to finish that work. So I'm gonna suggest we continue to work on that for the, into the next year, if
What
that's okay.
section? What section is that?
That's not in the bill.
It's not in the bill because we hadn't landed it.
That's 34.
It was the, mobile home park lot, rent increases and trying to keep them affordable, which we want very much to do, but I don't think we have had the time to finish that work. So, Cam, let's go through this.
Yes. I do have to print my remarks.
Okay, yes.
Good morning. Cameron Wood, Office of Legislative Counsel. I am going to get us back to the conversation that we were having yesterday, so give me a brief moment and I'm gonna.
Are you gonna start with immigration status or credit score?
Where would you like to begin?
Why don't we simply finish the credit score and check that off? Because I think we have you've now added language about those who enroll and those who are disenrolled and keeping track of them.
Okay.
And then if we can sign off on the credit score piece, then I'd love to move to the perhaps more challenging piece.
While there's quiet, I just want to say that appeals is what I'm glad we're talking about because that is what I hear the most about from developers. So great use of their time. Thank you.
Thank you for doing the work when I was not able to, so I am very grateful.
All of it's a great use of our time, but just that particularly, it helps me in my conversations.
Thank you.
Yeah.
Well, I think I also, okay.
I was trying to see if I had a physical copy with me and I don't.
I have a physical copy. We have an extra physical.
That's okay, that's okay. I have it. I know. All good, all good. Okay, we're on page 45, the bottom of page 45 on draft 4.1. So this is, as you can see here, I didn't highlight every single.
Sorry, what page?
45. So I didn't highlight every single piece of language here because we've reviewed this previously. If you all recall, this was in a version of your committee bill before that became S-127. So I brought that over from the last time we reviewed it and added a few changes. But I did just highlight the reader assistance heading there, so you know that it's new to this draft. So if you all recall, I'm going to skip the definitions for right now. I'm going to go straight to subsection B here. State treasurer creates, implements 2-year positive rental payment reporting pilot program. State treasurer contracts with a third party to administer the program. These here on page 47, this is what the third party administrator is required to do.
Right.
Excuse me, the last 2 lines there. Third party administrator is required to enter into an agreement with one or more participant property owners, ensure that information to the credit reporting agency includes only rent payment information after the date which the participant tenant elected to participate. Here's where I added some new language based on the last conversation we had. So this is going to require, this is in the subsection C, line 7, it would require the third party administrator to develop and implement a process for removal of participant tenants for failure to comply with program requirements, including failure to make timely rental payments. That was not a requirement previously, but I believe that the discussion was that that is how the program is anticipated to operate.
Yeah.
And I will clarify because Director Wasserman just came in.
Has just walked in the
I have
door.
not sent this to the state treasurer. I was not directed to do so, so I can't say that they have signed off on this, but I will get us going for now, right? So this is, again, the third-party administrator would be required to implement this, a process for removing participant tenants for failure to comply, including failure to make timely rental payments. It would leave it up to them to kind of develop that policy with the state treasurer's office. Subsection D, so this is language that was in your previous version. You know, they have to have a form for participants to use to elect participation or elect ceasing participation. And what I thought was important to add here is that the form has to include a statement that the tenant's participation is voluntary and the tenant may cease participating. And so I added some language there at the end of that subdivision. So the statement will also have to include information that the tenant may be removed for failure to comply with program requirements, including failure to make timely rental payments. Wanting to put the tenant on notice that that is potentially a requirement here.
Right?
Okay, so.
Becky, do you have this so that,
I don't, I will.
Here, let me-
Online right now.
It starts on page 45. Okay,
and
so.
47 is what we're just looking at, and then there are more changes on 49.
Yep, so then the remainder of everything here stays the same. So you have the program agreements, so the property owner has to agree, not to charge the participant, to participate for the duration of the program, to comply with the requirements, provide information as the state treasurer requires. I'm on page 48 now. And then, here that, it's the hope that the contractor, the third party, administered here is recruiting landlords who have a variety of types of dwelling units, units that are geographically diverse across the state and at least 5 dwelling units. The treasurer can terminate the program at any point. And then finally, we get to page 49 where we have the reports. And so what I've added here, this is, language that we've reviewed previously, but, the information that will come back to you in the interim report and then subsequently the final report, the number of participants, including, trying to break out that information, via demographics. So you have it. And then B and C here, the number of participant tenants who cease participating in the program voluntarily and the number of participant tenants who were removed from the program and for what purpose. You had previously the number of individuals who ceased participation, but as I was kind of discussing with some, you probably want to know the difference between those who ceased participation voluntarily versus people who were removed from the program.
Right.
So I simply broke it out into 2 subdivisions for that purpose.
Right.
And that's the only.
Okay,
that's
and
the only other
I
change.
think that answers the need that Randy had articulated, and I'd love to hear from Becky.
Reviewing this, so Becky Wasserman, State Treasurer's Office, reviewing this quickly, I don't have any issue with.
Right,
with
I think this clarifies the
changes.
concern Randy had.
I guess my only question would be, I'm just trying to find it now, for the report,
Mhm.
where it says for what purpose.
It could
I'm
be
just
as simple as failure to pay,
Yeah, I'm
failure
just
to
wondering-
participate, failure to live up to the expectations of the program.
I like to know failure to pay rent.
Yeah.
Right, I was just wondering if we could maybe change it to something like for what, and the reason why, because I want to make sure that we're answering our question for what purpose, because I want to know that we know what the intent is, like, what you mean by
So-
purpose.
What would you suggest? That we're removed from the program and the reason why?
Yeah, and I think it's saying the same thing, I just want to make sure we know what you want reported to you.
Can we make that change?
I see no issue with it, if you would like to. Yeah.
Sure, okay, thanks.
I do have another additional comment, if I
Absolutely, you have the floor.
I just wanted to note that, in our original recommendation for this, we had asked for an appropriation, which was in the previous version. I don't see it here. And it would be difficult for our office to do this pilot without that appropriation, because the, structure of how we proposed it is that we would be paying the fees for the landlords during the duration of the program.
That's not a modest thing, that's a big thing. And I can't recall whether it made it through, because you asked for that separately, because we didn't have this bill yet, and we hadn't added it to our other bill.
It was in the last version.
And
then it was taken out. It was $100,000 appropriation.
but we didn't have credit score going to the house.
It was, the appropriation was in there,
It
and
was-
then as 127 was introduced, the appropriation was still there, but that was just a drafting
And then it
error
was
on our
taken.
part, because you removed the program from your committee bill.
That
as
is
you
it, we
introduced
removed, that was it, I knew we removed.
So when it
right.
went to appropriations removed the $100,000 appropriation, because there was no program.
So
for
we
it.
need to put it back in for our continued conversation, even though it's sort of nearing the end.
I didn't include it here because your budget has already passed the Senate, and it's,
That's okay, it's in yeah, and it won't have been in, but none of the spending. All right. That puts us in a funny spot.
I've only been doing this for 5 years, so maybe I should know the answer to this, but, is there a way to make it so that we have all of this conditional upon funding, or is that just implied? Because I hate to have an unfunded mandate, and then we add that condition, and then we advocate for the 100,000 in the committee of conference. Is that already in place?
you can add a conditional section that it's not
Yes.
required without an appropriation. I would say you would need that, because without it,
It's not gonna happen.
it's mandatory language that the state treasurer's office do this, so.
Is that thread the needle?
Well, it just makes it possible for us to be doing this at this point. But
That would work for our office to let a conditional language, but I just did wanna make clear that we would be able to do the pilot without that.
If you recall, there was some language in the House version related to the VHFA off-site construction report that was similar. It said that if an appropriation was not provided, then VHFA was not required to do the report, so we could add some similar language in here to that effect.
No. I think we need to add it. I would like to make the language open enough and flexible enough for it not necessarily to be state money. We might find $100,000 somewhere else. I mean, it doesn't necessarily, can we make it, it was $100,000, right?
Right. I think,
Is it possible for us to make that language flexible in terms of where the money comes from? I mean, if the treasurer found it in some other place.
I just don't know that I can, without speaking to the treasurer, I don't know that our office can commit to being the ones to try to find.
No, I'm not committing you to it. I'm just saying, I think it would be great to have language that, because it wasn't specifically charging the general fund for that. It was just identifying what the cost. Cam, can you remind us?
I think it was an appropriation from the general fund
Yeah.
initially drafted.
He's always finding money out of corners.
Well, I think if we found money from another pot in our office, we would have to come back to the legislature to ask to use it for that purpose.
Fair enough.
So general, I'm just trying to think of, from the general fund or another source, we couldn't add or another source. I mean, I just think if there is a way that we're all gonna be trying to find money, given how much is gonna be cut, depending on what happens with the federal government and the budget, looking at the potential cuts that we're facing, we're gonna be looking at other sources for a lot of things. And it just strikes me that if there is another source, it might make some sense to have it considered.
Should I take some of the language from the baby bonds program and say, some other private source that?
I just don't know that I can, commit to saying the treasurer's office will come from another private source. It could be from another state source that,
Then let's just leave it.
yeah, I think.
Let's leave it for the moment then. I don't want to complicate things. Okay, great. If we could just add in, so that we would add in at the end, just as we did before.
Yeah, it'll just be, I'll probably just add in a section right behind this one, or, a section.
Okay, and keep it with it.
27A that just says that it's contingent upon receiving funding from the
Okay.
Assembly for the purpose.
Implementation of this. Right.
Okay, so that's the rental payments. Before I move, Madam Chair, are you and the committee comfortable with what we've reviewed this morning?
I think Randy, I think Randy's okay. I think we're in good shape. Yes, Dave?
Yeah, I'm really not.
Oh, with the credit score?
I'm really not. Positive credit reporting, I'm really not. I fully respect that that housing rental payments are a significant portion of people's budgets. But I think that we should be encouraging accurate reporting, both positive and negative, of rental housing. And I think that we should be assisting the landlord in assessing the risk of potential tenants while at the same time rewarding those who pay their rent on time. I find this all kind of shadowy and feel good. And then we also have government paying for it in the end. I haven't heard anything to dissuade my concern about the program. So
Oh, I'm sorry.
I'll leave it at that.
Yeah.
It's very fair. I see the concerns. Why I came comfortable with it, maybe not with the government paying for it, but is the fact that if they get dropped out of the program, if they stop paying the rent, the landlord still has every right to file with the credit reporting agency about what they're owed. And so that's where I felt like there's still that mechanism that's employed. This doesn't prohibit any of that. I see your point. I don't know how you feel about us
I
paying
came
for
to
it.
the point of saying that if you're reporting something that is positive on someone, that's a benefit to that person. I do feel it's deceptive to hide the other stuff and not report it. At the same time, and that's why I insisted on the part that we added here, so we get some statistics of how many people get dropped because they have bad credit, and that will inform us as to whether or not this is as offensive as it could be, or whether it is just marginally uncomfortable.
No, and I'd say this is a pilot. This is a pilot to see, it will tell us a lot about actually who's paying their rent, who's not paying their, who, this is an incentive for people who want to improve their credit scores. That benefits
Admittedly,
our
it
state.
is also a partial because not every landlord is going to participate in it.
Right.
And I know, certainly from experience and from what I've heard from other landlords, that those who do credit reporting, want to do honest credit reporting. There are some large credit reporting agencies will report without a social security number and so on, but it diminishes the value of credit reports generally if you only get positive information as opposed to not getting negative information in real situations.
And the
Even
merit,
marginally in a test program like that.
and the merit, and why I think this is worth doing it is I just can think of, I'm not gonna say his name, but a buddy of mine from a while ago, I ran into him, he was just getting back on his feet, and like the only thing he did, he had a job and he had an apartment. In order to build back that credit, this would be an opportunity for him to show that he's turned a corner, so to speak, without getting credit cards that they're not giving to him. So
Yeah,
I see this as a lift up, a handout, not a handout, but a hand up.
hand up. Great, so on this section, it's, I think there are probably four in the straw poll on this section, 4-1. Right.
I'm going to simply jump to page 42 real quick, because I simply want to acknowledge a change here, a language change, not a substantive change. If you recall, there was language in here related to brownfield funding that was appropriated in FY24, and it was
Right.
kind of being diverted to the Environmental Contingency Fund. JFO discussed with our office, and this is the language that they would prefer to use, and they will be putting corresponding language in the budget to accomplish this task as well. So I'm simply highlighting it for you in case you are reviewing the bill and you're asking where that section went or what does this section mean. No substantive change. This is just the language that JFO wants us to use for the purposes of accomplishing that task.
Okay.
So it's in fiscal year 26, Secretary of Natural Resources is authorized to disperse up to $2 million from the Environmental Contingency Fund for the assessment planning for the grounds. So just making sure you're all aware and asking, if you ask, why do we have blue highlight in our draft? So, okay.
One question that I would just raise for the future is the blue highlighting, and I've seen this in a number of other drafts and so on, is very difficult to read.
Only
we
when
can-
it's printed.
The contrast is, and using a lighter color that is more of a contrast would be helpful.
Yes, sir.
Thank you. I'm so glad you said that
Positive
because it's
feedback.
fine it's fine here,
Mhm.
but on the printed
On the
page.
printed page.
On the printed page, yes, it does come out difficult.
Right.
Yeah.
Thank you.
Okay.
But the benefit is there's less reading to do.
Well, that's true. The other thing is it takes more time because you're trying to decipher it. Okay, let's, shift to immigration status and citizenship status.
Yes, I'm gonna get us there. So this is gonna be to page 24. It begins the bottom of page 24 on draft 4.1. And there were two things that were being discussed. My recollection, first, on page 25, this is the language regarding landlords and the information they're able to ask for from a prospective tenant in order to conduct things like a background or a credit check. And if you recall, the language that came over initially from, or the language that was being reviewed in House General that's in their proposal of amendment to 127, it said that a landlord shall accept any of the following, and then listed social, individual taxpayer identification number, or government issued identification. This committee discussed, and I brought this language back to you yesterday morning, which would say that, you know, a landlord may request a social security number. However, in the event that an applicant doesn't have a social security number, the landlord shall accept one of the following. And then you remove the subdivision 2 that was a requirement that that information be on the residential rental application itself.
Right.
So that's where.
And this
I
is
haven't
the
changed
compromise.
anything,
This is the compromise we reached with the Landlords Association.
And I haven't
And
changed
Chris is
anything.
here to confirm that. Right. And then the other changes, let's just review the other changes as we all hold that.
I didn't make any changes to what,
No?
just to what was there yesterday, but just to review it again.
If you
briefly.
review, and just remind us, because the Judiciary Committee was, if you could just represent, I read Notter's statement yesterday that supported,
Right.
supported this work, and,
So in section 13 here, this is page 26, we will be adding citizenship and immigration status into the protected categories or classes of individuals in public accommodations. And then throughout the next section 14 in the Unfair Housing Practices Act, it would be adding citizenship and immigration status throughout. And then when you get to page 30, adding a subdivision D and a subdivision E. Again, as we kind of, discussed, in the event that there are changes at the federal level, verification of immigration status or differential treatment on the basis of citizenship or immigration status shall not constitute a violation. And then similarly, for the purposes of determining the risks and remedies for lenders, financial institutions, et cetera, providing them with the ability to take into account immigration status and determining, whether to issue credit. As I mentioned yesterday, there are some federal dollars to housing that require the funds be, go to individuals who are lawfully here in the country. So subsection D is kind of required to cover those instances currently. And then as we talk to subsection E, federal law specifically authorizes lending institutions to take into account immigration status when determining to issue credit. So my recommendation to you all is to have that similar provision. Senate Judiciary did look at it, and I think they commented that they are in favor or reasonably in favor. I don't remember the
right,
exact.
with these qualifiers, with the federal qualifiers.
Yes, ma'am. We particularly reviewed those two sections in the Senate Judiciary. So.
So, Thomas,
Who did you say was in favor of this?
look, we had a Senate Judiciary review it,
Sure.
and they were fine with it with these federal qualifiers, which is a federal law. Who requires?
And I was trying to remember, did Chris Delia comment on this? So
They're fine with this.
neutral on it.
Bankers are protected under federal law, the landlords aren't. And there's still that nagging concern in the back of my mind that if a landlord makes a decision that I don't want to rent to someone who I'm concerned maybe in the United States illegally, and I'm not able to inquire about that, one. But if I do know it and express that as a reason, because that is a potential credit decision. The decision is this a tenant who's going to be here do I have comfort that this is a tenant who's going to be here for the duration of the lease, is not going to leave abruptly and so on. That is a nagging concern, I think, for some landlords.
And I would respond to that of saying, in my research that I've done at the federal level, it's not clear to me that the federal protections explicitly apply to individuals who are here unlawfully. And so I think there are arguments that the Fair Housing Act does apply to people who are here unlawfully. However,
Well, does the
What
present,
I
does the
can't-
law apply to people who are here unlawfully, who don't pay their bills on time and would show up in a credit report?
That's one of
There's
the
nothing that
reasons to
would
improve your
say
credit
that
report.
you, as a landlord, have to rent to somebody who's got bad credit, whether they're here legally or illegally.
and there's nothing here that would change
But
that.
nothing
assessment.
changes that.
Senator Brock, I don't think there's anything that changes that, but I think if you're, what I was thinking as you were talking, the point has been raised about if you're a landlord and you are concerned about the prospective tenant potentially being removed from the country because they're currently here unlawfully and the risk that that associates to you as a landlord. What I can't guarantee is whether this language that you're adding into state law is going to specifically be extended to individuals who are here unlawfully or not. I think there's an argument that it will. And therefore, I think in those situations, a landlord would be putting themselves in potential liability if they refuse to rent to people who are here unlawfully. So I think an argument would be made that it would prohibit landlords from asking those questions. Now, as we talked, I don't see anything of a landlord, I don't see this stopping a landlord from saying, as some do, I've seen them, you have to have a minimum credit score of X, or, you have to have income that is a minimum of X% of the rent. If they're making those determinations of who to rent to
For
based
everybody.
on those kind of racially neutral things,
Yeah,
I don't think that is going to put the landlord at risk. There are always going to be arguments that can be made based on specific factual circumstances, but just as a general matter, as long as their
as long as the
As long as the
requirements are
policies
equitably
are-
applied, I think that every landlord is protected, and this gives them an opportunity to ask for something that really may anchor it further. So I think to talk about threading the needle, I think we have threaded the needle on this one pretty well. Thomas,
You can require references, right? That's not, so if you.
right, we don't, that's it.
Yeah, we're requiring landlords to be more sophisticated than in reality that they are. They're not backed up by lawyers and counsel. They're not interested in end arounds. They just want to know who they're renting to.
Right.
And having been an expat, living outside the US for most of my adult life, your immigration status, my immigration status, was pertinent to every person I ever rented from. And the same is true here. So it's not about whether they get lifted in the middle of the night by an ICE agent. It's about the fact that they actually live somewhere else, that their home is somewhere else. And it introduces an element of risk that they're not going to be there, not because they're getting lifted by ICE, but because they're going to return home when their economic benefits have been made and it's time to go to return to their family.
But that doesn't mean they won't fulfill their lease obligations.
No, but the
I mean, there's
reality,
nothing.
but the landlord should have that information. That's the whole point. Why shouldn't the landlord know that they're that they're either a green card holder or not a green card holder? And again, I'm not trying to shave this apart as a issue of illegal aliens versus ICE and all that kind of stuff, which I think is being conflated here. I think the pure fact is that as we saw before, our small business owners, which landlords are included in that, which equate to 87% of the state, and I'm sure that this landlord statistic is somewhere in that region. These are small timers who aren't going to be able to understand this legislation, and this is a risk reducer for them. It's just information they should have.
Thomas?
I understand it's from conversations with all, it's relatively settled law that landlords can't be accused of what is it called, housing immigrants and then be liable for doing so. But this is an unsettled time. And so my
I'm
question
not
is,
equating it to that either.
right, I'm not saying you are, but what I'm wondering in these unsettled times, and who knows what might be happening in the next 4 years, do you see this as possibly a protection to some of our landlords, knowing that if they do house and lease to those with immigrant statuses, they can say, well, listen, I couldn't discriminate on this.
You know, again, I think we're kind of going to third, fourth order effects. This is a first order effect. Will the person remain, is there an increased elevated risk to rent to someone who has an immigration status other?
Right. Every landlord, if they equitably apply it, David, can ask for references. And if a student is here on an immigration status, there's no reason to assume if they have a letter of reference from that university where they're doing their work and they know the time frame, they're signing a contract, they're signing a lease. They know they're going to be there for that amount of time. There's, if you equitably apply reference checks for everybody, you should be able to cover and underscore your confidence in renting to that individual. I think that there's nothing here that doesn't allow a landlord to do that and to have an interview with somebody. And we've heard this would apply to very few people and in this state, and which in some ways we wish it would apply to more, because to go back to our earlier conversation, we need more workforce. And we need to solve and resolve our federal immigration laws.
No argument whatsoever.
Yeah,
No.
I just think we have the opportunity with interviews and references to clarify exactly your concern.
Okay, and hopefully in the near future, when our federal immigration laws are a little more, or quite a bit more mature than they are right now, that, you know, this kind of question will be moot, because you can ask them the immigration status and you get a satisfactory answer, and it does reduce the risk to the landlord. It's just, you shouldn't have to do an end around with reference checks and what have you.
Yeah,
That's
I
a
don't think reference
sophisticated
rents are
landlord.
end around. I mean, I think they're pretty standard.
So a few quick points. I don't see anything in the language that's going to prohibit a landlord from asking someone's status. However, I do think that an argument will be made that if you're asked, what are you asking the question for?
But you mean the purpose? Correct question.
The purpose of what you're asking for, because if this were to go into effect, I think if a landlord is saying, I'm not renting to certain individuals, even individuals who are here unlawfully under this language, I think that is going to open that individual up to a claim of discrimination under this language. I think if this language goes into effect, and a landlord is asking the question, it's potentially opening them up to a complaint. Because if that's here and you're asking the question, you're potentially putting yourself in the situation where the argument's going to be prima facie evidence of why you didn't rent to me is because you asked me about my immigration status and denied me. So I think it is potentially opening landlords up to a complaint there, or the ability for an individual to take the fact that a landlord's asking the question and then, you know, make the complaint based on that. So, as you all know, these are very fact-specific cases, and it's going to come down to what is the policy of the landlord? Are they applying it equally to everyone? And what are they doing with that information? Is there a pattern of behavior, etc.? And to the one other question was asked, Senator Chittenden, there have been multiple circuits, including our circuit, the Second Circuit, that has said renting a loan to someone who is undocumented, whether the landlord knows or not, isn't in and of itself a criminal violation of federal law. There is a crime to harbor individuals who are here unlawfully, and courts have said that the mere fact of you renting to an individual who is here unlawfully without additional evidence of you trying to divert federal authorities from determining that the individual is
It's not a
there,
criminal.
et cetera, it wouldn't rise to a criminal offense. I will acknowledge that a lot of these things are potentially in flux, which is why,
We
the
have
other
this
committee
disclaimer,
asked
okay.
for subsection D. It's not a small matter that you're adding this to the statute, and I can't guarantee outcomes here, as you all know. These things would be determined over time by the Human Rights Commission and by the courts as far as how extensive the protections would go and what patterns of behavior would be potentially unlawful. So I'm trying to emphasize the fact that I can't tell you one way or the other, this is what landlords will be able to do moving forward or won't. I can try to give you an assessment of how the courts are going to look at it.
So I think we've done everything, in your work, Cam, and I appreciate what you've done to make this, more palatable for landlords and, for those who, yeah. And for those who want to ensure we have no, can't even finish my own sentence.
Would you like me to hit very quickly on some of the other
Sure.
minor things that we've talked about?
I mean, I guess I feel comfortable with how we've landed this. I feel like we're ready to, I think we're in pretty good shape on this. And I feel comfortable, particularly with Angela weighing in and, everybody else who's weighed in on this. I feel good about this. And it was, our members of our committee asked for the judiciary to weigh in. They have. I feel relatively safe in moving this. We protect more Vermonters who are here, and we also are protecting landlords as well. So I think we've done good work on both sides. Thomas, you had something you wanted to add?
No, I thought you were queuing up to move the whole bill. Is that what you're trying to do this morning?
No, I think you have one more change. Yes, I am trying to do that, but I would love to have you finish the additions that we added.
Not an addition, it was just.
Because we just added.
That was added, but that's just the version that passed the Senate. So I'm not gonna go through anything there, not my sections. I just wanted to mention on page 23, this is the landlord certificate piece. There was some conversation about the report that's at the end of that.
Right.
So this is, again, on page 23. I had a brief conversation with John Gray, who was, covering this portfolio last year, and he was, one of the primary drafters of the housing bill that you all passed last session, which is what made this change. It's here in the bill, simply carrying over because we're striking what you all did last year, inserting new language, and so this is included because you all asked for this change last year, you all, the legislature. I think there was just a general question about why did we ask for this information? In talking with John, it was information that, my understanding is this committee wanted in regard to the landlord certificate. The information is currently made available to the public in a sortable spreadsheet, and this would just go to an aggregate of the data provided to you all. My understanding is the request was because you wanted the aggregate information regarding what rentals are available throughout the state to better make policy decisions. So that's my understanding of why it's there. And I'm happy to make changes if you all want it, but it may be information that you all
happy to
would
have
find
this,
helpful.
Given those, I'm not, I think we're very keen on appreciating and understanding the entire picture of our rental housing market, who's in it, where it is, and I think that as we look at our housing discussion, particularly, all aspects of our housing, I think that the more housing information that we have, the better, and I think that's why we were asking for that.
So
I'm fine with keeping it. I don't, it's not a problem for me. Anybody else? Thomas?
Fine with this. I was going to raise one more thing regarding the bill.
Yep, and we have one more thing we have to land. in the bill after we okay with this language? We can move on. The other thing we have to land is the universal design piece. And, that's the last thing we have to land. I am fine with just keeping the task force as it is. And then we would have two task forces. I talked to Polly Major again, and she thought this would actually be helpful in our conversations going forward on, particularly on residential development, and that's.
I know you were out of pocket yesterday. Did you see the email from Commissioner Farrell on this?
No.
Okay,
So
so
I apologize, and I have no computer at the moment.
this is what he said, and I think he sent it to the whole committee. But he said, "Good afternoon, Chair Clarkson. We have engaged with the Division of Fire Safety regarding the Universal Design Study Committee in H479. We are in agreement that this study is not necessary. As an aside, but relevant, I question DHCD's ability to take on yet another study report, given the likely budget as drafted will result in a decrease in the size of DHCD." So I don't see this as harmful, but I worry that if the administration is now coming out saying we don't need it and we don't have any resources and the budget's getting.
And they're the ones charged with carrying it out.
Yeah, so I don't know where that leaves it, but.
Thank you.
Highlight it.
Thank you. This is the minus of being out of pocket
Yeah.
For a day, for those 12 hours.
I won't volunteer where I know you were yesterday because you're on YouTube, but I know you were out straight, so.
Yeah, no, it was a must show event of a personal thing. I had to be, I was here for the morning. Well, given Alex's response, what is your pleasure? To strike it at the moment? It will be in for discussion as the bill goes back.
I could go either way, Madam Chair, so I just don't know where you're landing on this.
I think it's important work to do. I just think that it's hard to charge a department that is facing
Budget
cuts. We're working on those cuts.
Section 5, this section.
It's section 5, universal
Page
design.
13.
It's page 13.
This was the testimony we had yesterday from Representative Burrows.
Yeah, or 2 days, yeah. On Tuesday.
I drink too much coffee.
No, it's okay. You're speaking it up. It's okay.
You can keep it as is, you can strike it, you can give the assistance of the committee to a separate entity. I'm only acknowledging, so you're all aware that is an option if DHCD is saying that they don't have the capacity. If it's a capacity issue, you could have another entity provide the assistance.
The question is, who at this point has the capacity? And we can perhaps work, if we strike it, we can perhaps work on that between now and the conference committee.
It is still in the House General's proposal of amendment to 127.
Oh, I'm clear. I'm clear. So if I'm not clear who else could do this study, and giving it, the other option we have that we could consider is giving it to the committee, the task force that is working on the energy and statewide building code. And we could give it to that committee to review and consider. But they would not have the time or capacity to do an entire study on its import. What we're hoping for is that this study committee's work would then impact, hopefully, the setting of a statewide building code. So it's a little challenging. So I would, with regret, until we can identify, is there any other body that would be capable, and this is maybe, that would be capable of doing this?
That's a question I would ask Damien, because this is really his area of expertise, not mine.
Yes. So if we're trying to move this bill today, we might consider striking this and just continuing to work on it and have who to send it to in the work that we do in the next few days.
You can keep it, you can do a floor amendment if you would like. If you're wanting, the bill to be out, you can strike the section. It's in the House version, as I said, that's still moving, so
Thomas, we're just talking about where to send this, if we aren't, if the DHCD is not feeling that they are able to do this work. This is important work. It needs to be done as we look at the statewide standards, building code standards. So I'm reluctant to cut it all together. I don't know who to send it to, and we'll probably won't know that by the end of this morning.
Yeah, you were floating that, Representative Walker, he has another committee that you were thinking about folding this into. Is that not his name?
No, Scott Campbell.
Scott Campbell.
The challenge is that's a task force that is looking at the energy codes and the statewide building standards, both. I had talked to Mike DeRocher, who was not able to take it on in his work. But I did put Elizabeth Burrows and Mike Rocher in touch with each other, so because Mike needed to appreciate and understand what universal design was, which he wasn't as clear on. So I've got those two working together, and it's possible that it may result in her coming and presenting and furthering that conversation with, as you know, they're working on the international residential building codes.
I noticed that Susan's in the room, and I wonder if she might have thoughts on.
She's a different
Yeah.
task force altogether. But it does affect people with disabilities, but not developmental disabilities necessarily, but physically, this is more for a range of physical disabilities. And universal design is really just meant to be for the whole package I don't know who to give to challenge us with. We could keep it in and do a floor amendment once we have worked out, because this is going to go, this language now will go to SNRE, or this bill will get referred to SNRE. And we have the opportunity at that point, if you I'm in touch with us, ask for a suggestion on that.
We got it.
So we're saying it's also all section 5 plan. Is that correct?
Yeah, all of section 5, right. And the challenge is, at the moment, the Department of Housing
They say they
and
don't have the
Community Development
capability.
isn't able to deal with it.
So the
So we
question is,
We can either keep it, so that's the question. Hi,
I like that. Keep it, and then we'll have more time, and if we need to do a floor amendment, we can
I think
address
we
it
can
then.
do that. This is going to SNRE. This gives us time to do that.
this gives us time to do what?
To find
someone
another,
else who
like,
can do it,
another
or
entity to
to
do.
recommend by amendment dropping it. Is that? Now, are you
The
gonna-
amendment could be either to drop it or to send it to a specific place, not the Department of Housing and Community Development.
Well, so I don't know much point of sending it to a different place if we haven't determined that they have the capability of doing it.
I think at this point, that I would propose striking it, and then if we can find another place, we'll add it
Then
back
put
in
it back
with a
in.
specific
I think
place.
that makes more sense. Now,
I think,
the other issue is the request to remove the Division of Fire Safety from that because they believe it's not necessary now. I'm not
no,
sure
they
why
don't know enough to say, that Mike admitted that he
didn't know enough to
but if
say
you're striking the
that they
section,
should drop it. If
it
you drop the
doesn't
section,
matter.
the whole thing goes for now, and we have
Right.
a chance to look at it. So that's
So,
probably the right
I just
answer.
needed to eat before this presentation.
Yeah.
I apologize to everyone.
Okay,
But it is really good.
so we are,
Striking section 5.
I think at the moment, let's strike section 5, let's work on trying to find a place for it to go and to be done. And,
I will-
let's,
Yeah, I mean, I think it's an important thing. There's no question about that. I think it's an important thing and we shouldn't forget, but we've got to have somebody to do it. We have to have the money set aside to do it. We haven't done that.
Just for your information, and if communication needs to go to the proper individuals, I believe that the Senate budget included $15,000 for that committee. So if you're striking it, if there needs to be, I'm just make sure you're aware.
right, I appreciate, but we may not have struck it all together, we just need to find
Understood.
another place to
Understood.
do it.
Just making sure you're aware.
So it's a call out for everybody out there who's interested in this. Okay, let's go back. The only thing we have not landed, credit score, inclusion, Keisha. We have, I believe you're supportive of that work, and, that we have a straw poll, which is a 4-1 vote at the moment.
Okay, great. Yes.
So immigration and citizenship states, this is our last thing that we need to land.
Before my amendment.
We don't have time, this bill is at the moment going straight to SNRE. with the appeals language. So that is where wetlands would be considered. I spoke to the pro tem. That is where that language will be considered.
What about the tier one opt-in, opt-out?
I haven't seen that language.
I mentioned it for weeks. It's
But, no, you haven't
we
mentioned
voted
for
it out of this committee last biennium.
Yeah, but we don't have it as an amendment for this bill right now.
Cameron has it.
It's in S-133, we can pull it up. It's Ellen's area, but.
Is it long?
It shouldn't be, it's a sentence. It would change opt-in to opt-out. I mean, I'm
But
sure
that
the
often
vote,
has big implications.
that's what we passed out of this.
Okay, can we let's just land immigration and citizenship status first, and then we'll consider the other. Okay. Right now, we are looking at sections 11 through pages 25 through
30.
page 30. We are looking at this, including our housing and public accommodation protections.
This is yours.
I got another.
Mhm.
I'm fine with where it is right now, Madam Chair.
Okay.
Okay, yeah. Where's Ellen go? Okay. Okay, so there is a proposal on the table. We've worked this language, and I think we have, I think we're pretty clear. And I would just love people to weigh in on where we are with the compromise with the Landlords Association. Randy, where are you feeling? Because I think we've heard from judiciary, we've heard from the landlords. I think we have had the input we have had, that we need.
I'm not particularly comfortable with it. I'm not particularly comfortable with the immigration piece, because that does represent a risk for a landlord. And banks are protected when individual small landlords aren't. And you should be able to make a decision that, look, this person represents a significant risk to me that I won't get my rent paid. And you're telling me I can't make a decision on the basis of that.
They have three ways of sort of looking at credit score. They have references, and they have the ability to interview people. I don't think.
Well, they don't have the ability to do what they do with every other landlord, and that is ask for a social security number, generally speaking, which is how they run a credit check. And most major credit bureaus use that as the determinant of whether or not you're going to get a complete credit check.
And we know that there are other avenues for accessing.
But not as adequate. And as a landlord, I could say, look, if I can't run a credit check on you, I will not.
So a credit check, knowing someone's credit score, way less assurance to a landlord than getting a cosigner. I am aware,
And getting a cosigner,
I am aware of a recent situation in Burlington where some students' professors co-signed for them because they are so worried about what's going to happen to all of their students. I want landlords to hear this because I actually worry, frankly, that the Vermont Landlords Association that's what they should be recommending. They shouldn't be recommending that we go against current civil rights precedent in the courts that says you should not set up a system that could have the impact of discriminating against one group of people. They should be getting help that just we're doing with standby guardianship, these are obligations have to have, but there's nothing in a credit score that guarantees that they get their rent paid if ICE disappears.
Right. Well, there's
what gives them some
certainly greater assurance if you have a credit score or you have credit to base your decision to make a financial decision on. And that's what landlords do. Landlords may very well, whether a person is legal or illegal in terms of immigration status, make a decision that you don't have a credit score, you don't have good credit, and therefore I won't rent to you.
They can still do that because that's not discriminating against somebody because of a protected trade. That's saying like they would to anybody else. I saw your credit score through one of these means, which they can do without a social security number. You have bad credit, you have no credit.
Or I got a reference that that gave me, that was.
Again, we're working on end arounds. The typical process for a landlord is to ask for an SSN and do a credit check and off we go. So that's the point where we disagree.
Yeah, no, I agree. That's what I'm hearing. So Randy, even though you supported this in our first version.
The issue is, as is often the case, is you have a bill and you have one section of the bill that you don't like. Doesn't necessarily mean you're gonna vote against the bill because you make the determination on the basis of the totality. On the basis of the totality, I'm gonna support the bill. On this particular section, I don't like it and I'd like to see it struck.
Okay, so that's
That's
where
what
I am.
I agree with.
Oh, okay, because I was about to strike a deal for wetlands or something, but,
Oh, wetlands.
I'm fine
I'm
with
fine with it.
wetlands.
well, that's what I'm saying, it's like you
No, I'm not.
could add that to the bill, make it
And
easier
that
to
will,
vote for it.
SNRE, we'll all go in and advocate for wetlands in SNRE.
We will.
If you are wanting to do that, you are welcome to do that. Thomas, where are you feeling on this language?
I'm fine with the language, but yeah.
In case, I assume you are as well. So that's a 3-2 straw poll on that section. So we have a 4-1 straw poll on credit score. We included their, while you were on, we included their reporting, those who disenrolled and who enrolled, right? So we have all the information.
Mm-hmm.
In universal design, we have struck because DHCD wasn't able to do the report, given the cuts they're facing. And so we're possibly looking for either someone else to do it or not having it done, sadly. And I think appeals we have landed. So I think we are.
By the way, at some point, we should ask them, what resources would you need in order to do it, so we understand that.
You're talking about universal design.
Yeah, we could.
And that's up to, for our information going forward.
Yeah, the conversation I'll have with Alex now, I mean, they're looking at person cuts, which is, I think, the biggest challenge, and that's what I think they were, I think that's but we will do that, and we can, I mean, I think they're looking at they have limited service people, they're looking for putting some of those positions into base, and anyway, I will clarify that with Alex.
Regarding the S-133 language, if it's going to SNRE, they're gonna take it up, but
That's not our jurisdiction.
Do we straw poll it though? Just to.
I don't understand it fully, and so no, it's not our.
That could be your vote in the straw poll.
No, I'm not gonna do a straw poll on something we've heard no testimony on. I think that's, I mean, everybody has an opinion on, we can certainly,
Can we work on it tomorrow? I asked when we took up many other subjects, not nearly as helpful to promoting housing, if we could take this up. I've asked multiple
I'm happy
times.
to take it up with SNRE. I am really trying very hard to honor other committee jurisdictions. I'm sorry, I made that promise to our pro tem, and I'm trying to keep it. And I would hope that, and I would hope the committee would.
Not to throw fuel on the fire. It is also an economic development issue. My constituents, that's the only reason why I'm suggesting that we could straw poll it to show some sort of support when it goes to the next.
Well, what I would like to do is have a joint time together for both our committees to hear about the entire issue. And that I will propose to Ann, because I think it's important for both committees, obviously.
I just want to say also, ANR worked on this language. This is an ANR proposal, working with DHCD.
Great, that's terrific. But I'd still like to do it with SNRE.
So you're committing to saying this committee supports, they'll look at that this year.
I'm committing to having a joint hearing on exactly that, on that language. I can't, my brain is right here on this bill right now. I'm happy, and I am happy to move forward with having a joint hearing on wetlands, because you're absolutely right. It, of course, has a huge impact on housing and then economic development. There's no question. However, it's not our committee's jurisdiction, and I have really worked hard to keep our lanes of jurisdiction clear. And I am happy to combine our efforts so that we hear that work together, but I am not happy to take a straw poll on something we've heard nothing about.
I support that, Madam Chair, and I say we move this bill forward, and then what I would support is Senator Rom Hinsdale or others would want to do a floor amendment relating to that, and then have it go to SNRE and have them consider it.
Well, this is already going to SNRE, so I hope
that's why I'd actually rather do it here, is because then one committee of jurisdiction is telling the other committee of jurisdiction, we have studied this as we should have, and we support it, and I think we could seek another day to do that. And then they have the ability to consider it as part of the normal process of business. Otherwise, as I mentioned to the chair, it's very likely it will come up without both committees of jurisdiction having the opportunity to have looked at it.
Right, but I have, because this has to go to SNRE, I am really wanting that to be taken up in SNRE. That is the appropriate place for it to be taken up. I'm happy to do a joint hearing on that exact subject.
This week or next week?
Well, we can see what we can do this week, but if not, early next week. So they will have time with this bill, but our session is winding to a close. So we're trying to move this bill along into the appropriate committee where it would be considered. And happy to do a joint hearing on this very subject. So I think that's where we need to be. So the natural progression for this will be to SNRE after we vote this out. So that's where it's going. So I think do we have a final draft? It would be include Ellen's language on the appeals. On the notation, it's got to go in 5 minutes.
I can create the draft 5.1. I don't know if Ellen has already done that or not. I assume she has. It would include the conversation that you all had about appeals this morning. There was the request from Director Wasserman to make that slight change and the information coming back to you on the rental pilot, adding a section related to the credit reporting, the qualification that they don't have to do that unless they're provided funding, and then striking section 5, universal design. I can do all of that.
Okay.
Can you work with a
Probably
motion?
not in 6 minutes.
With those changes. So it would be draft 5.1?
Yes.
Okay. Todd.
I would move favorably draft 5.1, alluding to what Council Wood just articulated. Does that work?
Great, and that would be the changes in the appeals language, the changes that we discussed and agreed to in appeals language, in credit score, and striking universal design, and those are the key pieces. Okay. Clerk, would you be kind of?
Yes, ma'am. Senator Brock,
Yes.
Senator Chittenden,
Yes.
Senator Rom Hinsdale.
Yes.
Senator Weeks, I'm a no. Senator Clarkson,
Yes. Thank you.
410. Reporter,
Keisha has reported the first housing bill. I'd love to have it done in conjunction with Thomas, and with all of us, we can continue to work on it
Yeah, the
together.
same thing that we did last time.
Yeah, exactly, and I'm happy to
as
help.
a lead, who should I put down?
Ron Hinsdale, because she did our first one, S1, so,
I will get you a clean copy as quickly as we can.
right, and we will take it up.
I appreciate you all being willing to express your discomfort with the immigration status piece, but still vote for the bill. That's really meaningful to me. Thank you.
Understood.
And thank you for your work on this. We've worked hard on this, and I really appreciate everybody's time and effort. And threading the needle has been a challenge, or some thorny issues, and I really appreciate our support for this work.
And if we have time now that the bill's out, to look at the wetlands and the opt-in as a
Next
amendment, that I would
Absolutely.
support
Next
that.
stop is to chat with Ann about this.
It's critically important.
Yep, I agree. Great, thank you.
You're welcome.
And I love floor amendments. It's starting to grow on me.
Are we done?
What?
I'm love floor amendments. They're growing on me.